Welcome to this podcast on conveyancing in English law. We will introduce you to the basic elements of land conveyancing as they relate to the study of English law for undergraduate law students and those taking the Solicitor's Qualifying Examination, the SQE. This podcast was prepared by me, Dr. Yannis, and is narrated by AI Voices. If you would like to know more about how this podcast was produced, get in touch with me. Let's get started by presenting the essential steps needed to prepare for completion in a conveyancing transaction. We are focusing on the most important tasks that both the seller and buyer must undertake after exchange of contracts and before the day of completion. We will also highlight how the client's mortgage should be handled, explore apportionments when certain outgoings have not yet fallen due, and explain the necessity of preparing a thorough completion statement. We will talk about land transaction returns that should be filed with HM, Revenue and Customs, as well as the statement to the client and the handling of money to ensure cleared funds are ready. Finally, I will walk you through a concise checklist for completion to confirm that nothing has been overlooked. Seller's checklist. The very first action is for the seller to verify that the transfer deed has been properly approved, with replies to the buyer's request for completion information having been given. The seller's solicitor should receive the engrossed transfer deed from the buyer, making sure that the buyer has executed it wherever necessary, including the plan if one is attached. The solicitor should then obtain the seller's signature along with a witness in good time for the completion day. It is also important for the seller's solicitor to obtain redemption figures for any mortgage or mortgages affecting the property, confirming the amount required for discharge on the completion date, together with a daily rate of interest if applicable. The seller's solicitor needs to collect the last receipts or other forms of documentary proof covering outgoings such as rent, in the event that apportionments of these outgoings will be made on completion. Next, the seller's solicitor prepares the completion statement, which should be sent to the buyer in time for proper checks to be carried out. That statement will list each item making up the total required at completion, including any apportionments. The seller's client should also be reminded to arrange for meter readings on or near the completion day. Where relevant for unregistered land, the seller's solicitor should prepare any necessary forms to discharge land charges. If a formal undertaking is needed to discharge the seller's mortgage, it should be prepared so that the process of using the sale proceeds to pay off the mortgage will be smooth on the day of completion.
The solicitor must make contact with the lender to confirm precisely how the discharge money will be paid over. The entire file should be reviewed, making sure there are no outstanding issues that might cause delay. The solicitor would be wise to create a completion day task list with all relevant deeds and other documents assembled and labeled. In cases where the buyer is entitled only to copies of some documents, these copies should be prepared and any originals that remain with the seller should be certified as having been examined. The solicitor should prepare 2 copies of the schedule of deeds being handed to the buyer, one for the buyer's records and one to be signed and returned to the seller's file. If chattels have been included in the sale, an inventory and a separate receipt should be readied. Any questions about vacant possession, including how and when the keys will be handed over, should be resolved well before completion. The seller's solicitor may be asked by the buyer's solicitor to act as agent for completion, and those instructions should be crystal clear. Estate agents must be informed of the arrangements too, especially if they hold the keys. Finally, a bill for costs and disbursements should be prepared for the seller client. Buyer's checklist. The buyer must ensure that the transfer deed has been agreed and that replies to the buyer's request for completion information have been received and are satisfactory. The buyer's solicitor will need to prepare or engross the transfer and mortgage deeds, then secure the client's signatures, along with any plan that must be signed. Afterward, the solicitor sends that engrossed transfer deed to the seller's side for execution by the seller. Next, it is time to make the essential pre-completion searches, such as the land registry search if it is registered land, or the land charges search if it is unregistered land, and confirm that the results raise no fresh complications. Once the title is verified, the buyer's solicitor sends a formal report on title to the lender, along with a request to draw down the mortgage advance, ensuring that the lender's instructions regarding insurance and any life policy are followed. A completion statement from the seller arrives, and the buyer's solicitor will scrutinize it to check that any apportionments or sums for chattels and the total due have been calculated correctly. The buyer's solicitor should remind the client about the date and place of completion and stress the need to have cleared funds in the solicitor's client account, combining the client's own contribution with the lender's mortgage advance. It is also worth confirming that any building insurance or life policy required by the mortgage has been taken out. At this point, the file should be examined to confirm all queries are resolved, the buyer's statement of account and any solicitor's bill is delivered, and the client pays any outstanding balance in sufficient time for clearance before completion. A final property inspection by the lender's surveyor may also be needed. The solicitor compiles a short completion day list to keep track of tasks such as verifying vacant possession and where keys will be collected. If completion is by post, the buyer's solicitor will provide written authority to the seller's solicitor to act as agent, or if it is personal attendance, the exact time and place is arranged. Estate agents are usually informed so that they can release keys once the solicitor confirms completion. The client's mortgage. The seller's solicitor obtains a redemption figure from the lender, making sure it is up to date. The buyer's solicitor submits a report on title and requests the mortgage advance from the new lender on behalf of the buyer. If bridging finance has been used for the deposit or shortfalls, that is dealt with from the ultimate mortgage or from the buyer's other resources at completion. The paperwork for discharging the seller's existing mortgage is handled by the seller's solicitor. A key point is that the buyer's mortgage funds must be in place so that the buyer's solicitor can transmit them to the seller on completion day, with no risk of late completion. The process of executing the mortgage deed is done alongside the transfer deed, and the buyer's solicitor will verify that all of the lender's conditions are met. Apportionments. Sometimes completion does not coincide with the date for outgoings like rent, service charges, or council tax. These sums need to be proportionally assigned between the seller and buyer. For instance, if the seller has paid rent beyond the completion date, the buyer should reimburse that proportion. A similar approach applies if the buyer pays an outgoing after completion that partially covers a period during which the seller enjoyed the benefit. The overall contract normally provides for this, often through Standard Condition 6.3 or SCPC 8.3, depending on whether it is a residential or commercial transaction. Usually, the last receipts or bills are produced so that the arithmetic can be correct, and the result is inserted in the completion statement. Completion statement. The seller's solicitor supplies the buyer with the completion statement that sets out exactly how the purchase money is arrived at, taking into account the purchase price, deposit, apportionments, chattels, and any other additional items such as compensation for a delayed completion. The buyer's solicitor then confirms that the total is accurate. This step typically flows from the buyer's request for completion information. Once the amount is confirmed, the buyer can finalize arrangements for transmitting the money on the day of completion. Land transaction returns. Immediately after completion, the buyer's solicitor is responsible for filing the land transaction return with Revenue and Customs, covering most transactions whether or not SDLT is owed. This means filling out the SDLT forms in detail, obtaining the buyer's signature where required, and ensuring any payable tax is handled promptly. If the buyer's solicitor is also representing the lender, then it is vital that the forms are signed or approved by the client beforehand, because registration at land registry cannot take place without the SDLT certificate confirming that any required tax has been paid. The paperwork is then sent to HMRC or submitted electronically, and once the SDLT-5 certificate is issued, that must be included with the application to register the transfer. Statement to client. The solicitor who acts for the buyer or for the seller should provide a clear statement to the client immediately after completion, showing where the finances stand. For the buyer, the statement will indicate the purchase price, any deposit, apportionments, the costs of the mortgage, the stamp duty, land registration fees, and the solicitor's own charges. For the seller, it will indicate the proceeds of sale, minus any outstanding mortgage redemptions, estate agent fees if being settled by the solicitor, and costs for the conveyancing. It is also wise for the solicitor to remind the buyer to ensure that buildings and contents insurance is now in place, and if it is unregistered land being transferred, or any different arrangement for the deeds, to confirm what is happening with those documents. The buyer might also need to be told about contacting utility suppliers to confirm that the buyer is the new occupier. Money. A key focus is ensuring the correct amount of money arrives on completion day as cleared funds. The buyer's solicitor must have the mortgage advance and the buyer's own contribution. Typically, these funds arrive by telegraphic transfer into the solicitor's client account. The solicitor then sends the balance to the seller's solicitor's account once all is confirmed. If bridging finance was needed, that should also be repaid once the ultimate funds are in the account. Because the standard conditions require direct payment, the solicitor must handle it properly, checking that the deposit is being released if still in stakeholder status. Timely payment avoids compensation for late completion. The seller's solicitor, on receiving the funds, makes certain they are indeed in the client account before giving up the transfer deed and keys to the property. Completion checklist. We will now emphasize the importance of a completion checklist for the final day. The buyer's solicitor should confirm that all pre-completion searches have been carried out with satisfactory results, that the sum required matches the completion statement, and that the client's and lender's money has been received and cleared. The seller's solicitor checks that the transfer deed has been executed by both parties and that any mortgage redemption figure is ready. The seller's solicitor also ensures that any undertaking to discharge the existing mortgage is made, or that the mortgage is already discharged. Keys for the property need to be dropped off to the buyer once completion is confirmed. Both parties verify that all necessary documents are exchanged and that all undertakings are properly given or released. With the actual completion concluded, the buyer's solicitor then proceeds to file the SDLT return and lodge the application at Land Registry, so the buyer's title is officially recognized. After that final wave of activity, the transaction is finished from a practical standpoint, and both solicitors can close their respective files once any final matters, including the storage or distribution of deeds, are resolved. We now shift gears to offer some explanation on title investigations. Deduction of title. We will begin by explaining that the term deduction of title refers to the seller's responsibility to prove to the buyer that the seller actually owns the interest in the land that is being sold. This means that before the transaction completes, the seller must produce evidence of ownership. The precise method of doing so varies, depending on whether the land is registered or unregistered. Where the land is registered, official copies of the title will be available from the land registry, reflecting the up-to-date state of the register. Where the land is unregistered, the seller will typically supply an abstract or epitome of title listing the documents establishing ownership. Time for deduction. Historically, deduction of title was often postponed until after exchange of contracts. At that stage, the buyer had to trust that the seller's title would ultimately match what had been described in the contract, or else exercise the right to rescind if it turned out that the seller could not sell exactly what was promised. However, in modern conveyancing practice, particularly as embodied in the protocol, the norm is for title to be deduced before exchange takes place. By having full knowledge of the title prior to exchanging contracts, the buyer's scope for questioning the seller's title after exchange is deliberately curtailed. This approach is reflected in the standard conditions of sale as well as the standard commercial property conditions, found respectively in SC 4.2.1 and SCPC 7.2.1. Seller's obligations. The seller's obligation is to deliver enough documentary evidence to the buyer to prove the seller's right to sell the property. In other words, the buyer must receive a clear demonstration that the seller holds the necessary ownership interest and that any previous dealings or mortgages are accounted for. The buyer, once satisfied, can then proceed to enter a binding contract with knowledge that the title is sound. Method of deduction for registered land. Official copies. The seller is required to supply official copies of the registered title to the buyer. These official copies come directly from the land registry's records and must reflect the most current position. The seller is responsible for the cost of obtaining them. The protocol recommends that these official copies be no more than 6 months old, ensuring that any recent entries or changes on the register are known to the buyer. Because registered land is organized around a central register, the official copies act as a comprehensive snapshot, showing the property register, the proprietorship register, and the charges register, along with the plan. Method of deduction for unregistered land. Epitomes and abstracts. In unregistered land, title is proved by title deeds. Since the seller is unlikely to hand over the original title deeds before completion, the practical way to show ownership is to supply the buyer with either an abstract of title or an epitome of title. Historically, abstracts of title, which summarize in detail all documents that make up the title, were common, but these have largely been superseded by epitomes. However, older titles may still rely on abstracts. An epitome of title functions as a schedule of the relevant documents, with photocopies attached, listed in chronological order. Every document is identified by date, type, parties, and whether the original will be handed over upon completion. Any plans included within these documents should be reproduced in exactly the same markings or colorings as the originals. The goal is for the buyer to have sufficient information about every significant event in the property's ownership history, from the root of title to the present day. Format. In greater detail, an epitome of title lists each document by date, describes the nature of the document, for instance, whether it is a conveyance or a mortgage, identifies the parties, and so forth. Good photocopies of these documents are essential. By attaching these copies and correlating them with the numbered entries in the schedule, the buyer can see precisely how the chain of ownership was transferred over time. This approach is simpler than an abstract of title, which typically provides a summarized narrative of every document in more elaborate detail. The root of title. Whichever format is used, an unregistered title always begins with the root of title. Common law dictates that a valid root be at least 15 years old. According to Section 44 of the Law of Property Act 1925, this root document must deal with the entire legal and beneficial interest in the property, must contain a recognizable description of the property, and must not contain anything that casts doubt on the seller's ownership. However, if the contract itself designates a shorter or otherwise non-compliant root, Section 44 is overridden, and the parties proceed on the basis that the buyer will accept that specified route. In general practice, a shorter route is uncommon because it leaves open the possibility that earlier defects or covenants might remain undiscovered. Documents capable of being good routes of title. The best possible route documents include a conveyance on sale or a legal mortgage that meets the requirements for a good route. Such a document provides a kind of double confirmation, because the buyer in the present transaction is investigating at least 15 years going backward, and the buyer under the root conveyance would likewise have investigated a previous period of at least 15 years. Taken together, it offers confidence that the title is sound for a combined total of at least 30 years. If there is neither a conveyance on sale nor a legal mortgage fulfilling these criteria, one might come across a voluntary conveyance or an assent made after 1925. However, as these transactions represent gifts, they may have been made without thorough title investigation, so they offer less comfort to a modern buyer. The dangers of accepting a short route. A short route, which is essentially a document less than 15 years old that does not fully satisfy Section 44, places the buyer at risk of being bound by earlier matters that have never been brought to light. It also potentially affects the ease with which the buyer can register the land with absolute title at the land registry. In many cases, the seller can indeed supply a traditional good route. But if the seller only has a short route, the buyer should insist on knowing exactly why the title cannot be deduced in the normal manner. The buyer might need to consult any lender if a mortgage is involved, and the possibility of defective title insurance arises if the missing pieces of the title cannot otherwise be remedied. Documents and events to be included in the abstract or epitome. In principle, every document affecting ownership from the root up to the current seller must be included. That means any conveyances, grants of representation, changes of name, leases, mortgages, discharges, and so on. If there is a previous reference to restrictive covenants that bind the property, the relevant deeds need to be included in the epitome. Endorsements, such as memoranda relating to partial sales or assents, must also be shown. Powers of attorney that authorize the signing of documents within the chain should be included too, as should documentary proof of any relevant event such as a death certificate or a marriage certificate that brought about a change of name or ownership. Documents which need not be included in the abstract or epitome. Some documents do not have to appear, although in certain instances they might still be helpful to the buyer. For example, land charges search certificates from previous transactions need not be included, but if the seller has them, it can be helpful to provide them because they show that earlier searches were carried out. Leases that have expired by the simple passage of time need not appear, and so do not have to be included. Additionally, any document predating the actual root of title is generally not required unless a document within the chain specifically refers to it. If a document in the chain was signed under a power of attorney, that power must be included, even if it is older than the root. Production of original documents. According to Standard Condition 4.1.3 and SCPC 7.1.3, the seller must, at his own expense, produce every original document relevant to the title. If the original is unavailable, a copy must be produced, marked or certified by a solicitor who examined it against the original. This requirement reassures the buyer that the copies or epitome are accurate documents which will not be handed over on completion. Finally, the epitome should distinguish which documents will be handed to the buyer at completion and which the seller will retain. As a buyer, one is entitled to possession of the originals for the property being sold. But if the seller is keeping part of the property or if certain documents affect multiple properties belonging to the seller, they may keep the originals and provide certified copies. A general power of attorney could be retained by the seller if it relates to other property. Similarly, personal representatives retain their original grant if they are still administering parts of the deceased's estate. Leaseholds. It should be noted that the deduction of title in leasehold transactions has additional considerations. The procedure is discussed more thoroughly in chapters 35 and 36. Nevertheless, the fundamental principles of showing an adequate chain of title and explaining any relevant encumbrances apply similarly to leasehold as to freehold. I want to shift focus now to the investigation of title from a practical perspective. Thoroughly investigating title is essential because it is the very thing being sold, the ownership interest in the property. It is a crucial stage, and it can also be quite intellectually stimulating once you grasp the fundamental processes involved in checking that the seller truly has the property rights they claim to have. We will explore how the investigation of title is carried out, starting with the reasons for investigating the title in the first place, and continuing through how that investigation proceeds in both registered and unregistered land. Reasons for investigating title. One must remember that the buyer, the seller, and even the lender each have their own need to investigate the title. The buyer's priority is to ensure the seller can transfer what was promised and to discover any title defects that could affect the buyer's ownership or enjoyment. The seller's solicitor, meanwhile, needs to ensure that the details in the draft contract accurately reflect the title to be sold, and that any issues are discovered in good time. The lender, if a mortgage is involved, similarly wants to confirm that its security interest will be effective if the borrower defaults. Seller's investigation of title. The seller's solicitor will investigate the title to enable accurate drafting of the contract of sale, which must reflect the correct ownership details and any encumbrances or burdens. By doing so, the solicitor can anticipate potential problems, address them early, and thus avoid unwelcome surprises later. Although the seller's motivation differs from that of the buyer, the technique used to examine the title is broadly the same. Buyer's investigation of title. Meanwhile, the buyer's investigation of title is essential so that the buyer can be confident in purchasing the property, untroubled by undisclosed defects. Typically, modern conveyancing practice arranges that this happens before exchange of contracts. Consequently, the contract itself tends to limit the buyer's right to challenge the title after exchange. So the buyer's solicitor needs to be diligent in raising any concerns or clarifications beforehand. Lender's investigation of title. If there is a mortgage, the lender must similarly be assured that there are no title problems that could undermine its security. If the borrower defaults and the lender tries to sell, undiscovered defects in title might reduce the lender's ability to recoup the outstanding balance. Often, the buyer's solicitor also acts for the lender, performing a single combined investigation of title. Alternatively, the lender might be separately represented or might ask for a formal certificate of title. In commercial contexts, the lender often requires that the borrower's solicitor provide a standard form certificate confirming that the title is indeed good and marketable. Investigating title in registered land. Where the property is registered, the seller will typically produce official copies of the register along with the title plan. The buyer's solicitor must read these carefully, verify that the seller is shown as the registered proprietor with the correct ownership class, check that the description of the property matches the contract, and review any charges or encumbrances. Furthermore, the buyer's solicitor should determine whether any overriding interests might affect the property. These do not appear on the register but may still be binding, so it is prudent to investigate them through searches, inquiries, and a physical inspection of the property. Later, a pre-completion search at the land registry will confirm that no fresh entries have occurred since the official copies were obtained. Points to look out for on the official copies and title plan. The buyer's solicitor must confirm that the property register's details match the contract. The buyer's solicitor should check the proprietorship register for the class of title and any relevant entries about restrictions or limitations. The charges register is equally important because it reveals any mortgages, covenants, or rights in favor of other parties. The title plan should be studied to see if the boundaries match the physical property. The overall aim is to ensure that the buyer is not buying less or more than expected, and to assess whether the property is saddled with unexpected burdens. Adverse entries, where the official copies disclose a negative matter, for instance, a restrictive covenant or a notice protecting a third party's interest, the buyer's solicitor needs to examine how this might affect the buyer's intended use. The buyer should then be advised, and if necessary, the problem must be dealt with ahead of exchanging contracts. This might involve negotiating with the party who benefits from the restriction, seeking indemnity insurance, or deciding that the restriction will not actually interfere with the proposed use. Documents referred to on the register. Sometimes the official copies refer to a document that is filed with the land registry, such as an older deed or plan. The buyer's solicitor should obtain a copy of that document to see its precise wording. A thorough reading can reveal critical details about covenants, rights of way, or other matters that might not be fully summarized on the register. Overriding interests. Because some interests bind a buyer even when they do not appear on the register, the buyer's solicitor must investigate carefully by asking the seller direct questions and by viewing the property. If, for example, there is a long-standing informal right-of-way used by neighbors, or if there is a non-owning occupant, these could be overriding. The buyer's solicitor typically checks for these by making local searches, sending pre-contract inquiries to the seller, and, importantly, inspecting the land. Unregistered land. Investigating unregistered land involves additional steps. The buyer's solicitor must do an index map search to confirm if the land might actually be in the process of being registered, or if there is a caution against first registration. The buyer's solicitor then studies the abstract or epitome of title that the seller has supplied. This entails examining all the documents in the chain and verifying that there is an unbroken line of ownership from the root of title to the present seller, and that no encumbrances have been omitted. One also needs to check the original deeds at some point, usually on completion, to confirm that no crucial details have been misstated. Events triggering first registration. The law identifies certain transactions that oblige an owner to register the land. If the title's history shows that such a transaction happened without subsequent registration, the buyer's solicitor should be aware of the formalities and potential ramifications for concluding the deal. This is critical because the property might not hold the class of title the buyer expects if it should already have been registered in a prior deal. Method of investigation of an unregistered title. Typically, the seller's solicitor will produce an epitome or abstract of title. To manage it, the buyer's solicitor should adopt a systematic approach, reading the documents in chronological order, from the root up to the present day, tracking any changes in ownership or name. An easy mnemonic is RLSDLES, which stands for root of title, links in the chain, stamp duties, description, encumbrances, execution, and searches. Root of title. The buyer's solicitor should confirm that the document identified as the root is consistent with the contract. At common law, a good root must be at least 15 years old unless the contract overrides this. If the contract demands a shorter root, the buyer must be cautious and might need an explanation or an alternative measure such as defective title insurance. The buyer need not look behind the root except where a power of attorney or plan is referenced. Links in the chain. The buyer's solicitor should check that the ownership passes from one party to another in an unbroken sequence, with no gaps. The presence of a break or missing deed is unacceptable. Any changed names, such as a seller who has married or changed name by deed poll, must be evidenced. If the chain is intact, the buyer can verify that each successive transfer is properly documented. Stamp duties. For unregistered documents dated before December 2003, the buyer must confirm that any required stamp duty has indeed been paid, evidenced by the proper stamp on the deed or, where relevant, a particular's delivered stamp for certain property transfers. Failure to comply means the deed is neither a good root nor a good link, and it can't be used in evidence. If the document is unstamped or incorrectly stamped, the buyer can insist on the seller rectifying it at the seller's expense. Description. The buyer's solicitor should confirm that the property's description is consistent across all documents in the contract, paying special attention to situations where part of the land might have been sold off previously. If a plan is referenced, it must be provided. Encumbrances. The buyer's solicitor needs to look carefully for any covenants, easements, or mortgages that might adversely affect the property. If the land is subject to burdens not disclosed in the contract, that can raise significant issues, especially if it conflicts with the buyer's intended use. The solicitor might have to investigate whether each burden truly binds the buyer, using standard land law principles, such as verifying the registration of any restrictive covenant as a Class D, E, land charge. Execution. Every deed in the chain must be checked for valid execution. Typically, for a conveyance or transfer of a legal estate, the deed must meet the formalities for valid execution, including signature and witnessing, so that the chain stands up as legally effective. Searches. Although the seller may not be obliged to provide copies of prior land charges searches, it is helpful when they do so. The buyer's solicitor must be satisfied that every estate owner was searched against, and that each search covered the entire period of that person's ownership, and that each transaction closed within the priority period of the search. If there is any mismatch or gap, the solicitor may need to conduct a fresh search. If an estate owner's name changed, the new and old names must both be searched. Ensuring all these checks are properly documented helps avoid unknown charges or prior rights lurking on the register. That concludes this explanation of how deduction of title and investigation of title are carried out when preparing for a property transaction, focusing first on the key obligations and typical documentation for both registered and unregistered land, and then moving on to how a buyer's solicitor systematically conducts the investigation. By following these recognized procedures, one can ensure a sound chain of ownership, protect all parties' interests, and proceed confidently toward a successful completion. Thank you for listening to this podcast, and have a look around Dr. Yannis' YouTube channel for more information on key FLK topics.